All right. Good afternoon, everyone. Welcome to the July docket of the Kansas Court of Appeals. My name is Tom Malone. We also have Judge J.C. Hurst and Judge Angela Coble. We are the panel for this afternoon's cases. We only have two cases on the docket this afternoon. I'll begin by thanking the attorneys for participating in this conference by Zoom. Without going into much detail, we just had some recent exposure to COVID on our court. And so at the last minute, we just decided it would be better and safer for everyone if we did today's hearings by Zoom. So I certainly thank the council for that last minute change. We have very experienced counsel on this first case, so let's just jump right into it. It's a case from McPherson County. It's case number 125485, entitled The State of Kansas versus Reynaldo Contreras-Avila. This is a state's appeal. We have Mr. Stephen J. Obermeyer for the state, the appellant, and Mr. Patrick H. Dunn for the appellee. Mr. Obermeyer, we'll begin with you. And first of all, do you wish to reserve any of your 15-minute time for rebuttal?
Yes, thank you, Judge Malone. May I reserve 4 minutes, please, for rebuttal?
That is granted, and you may proceed.
All right, thank you. This appeal demonstrates the tension to some extent that exists between the defendant's constitutional right to a speedy trial and how that is affected by the COVID pandemic, COVID-19, and more specifically, the Delta variant that came up in August of 2021. If I could just cover a couple of key facts here. The defendant was charged in late January of 2020 with 1 count of aggravated assault. This was before COVID. There was a 5-year statute of limitations, so it could have been filed in January of 2025. But at any rate, charges get filed, and then the defendant, then COVID hits in March of 2020. The defendant requested a new attorney. The case is continued for arraignment. There's an arraignment in July of 2020. And then there's a series of status conferences because there's a Supreme Court order suspending jury trials from about March of 2020 to April of 2021. And so in March of 2021, there's a Zoom hearing where the case was scheduled for a pretrial conference and jury trial the following August of 2021. There's a pretrial conference in August, and it's at that point that the county attorney who has an alpha-1 antitrypsin deficiency discovers that there is not going to be face masks during the trial. So in short order, I think the next day or so, the attorney files a motion to impose COVID requirements, COVID safety precautions, or in the alternative to continue the jury trial. That is heard on August the 23rd, which is August 24th, rather, which is the day before trial, which is on a Wednesday in McPherson County. After the hearing, the judge says we're using face shields instead of face masks, and that's as safe as we can get. And the judge actually, if you look at the transcript, which is volume 5, invited defense counsel or the prosecutor that if he wanted to dismiss the case and refile, he could do that. But even though we'd had this Delta variant, and even though the county health department said that McPherson County is an area of high contagion and a person had died within the past 2 days of August 20th, and 30-some people had contracted COVID during that time frame, that the trial was going to proceed, even though in other counties, Johnson County, for example, had suspended jury trials through the month of August. So there are no jury trials at that point. So at the end of the hearing, the attorney says, I have no animus to the court. explained his health condition again. He's in a situation where he is most susceptible to serious complication if he became infected. His wife is a nurse on the front lines of this, and he knew that the hospitals weren't taking people. So at any rate, that same day, the case is dismissed and it gets refiled. The refiling date, I guess the court can help me with this. The summons was filed, request for summons, and the complaint was filed in late October of 2021, the 25th of October. And this was 2 counts of aggravated assault. There was some difficulty getting a court date to schedule the summons, but the summons happened in February 15 of 2022. And then we're on to the races with the defendant wanting to file a motion to dismiss based on constitutional speedy trial. That's filed in June, and then the case gets dismissed in August. There are 2 arguments basically in the state's brief. The first one is that under kind of following State versus Gill, we have 2 cases that have been filed. Do we tack on the time from the first case to the second case in constitutional speedy trial or not? So the first issue under Gill is that there was no bad faith and intent by the state to subvert the defendant's right to a jury trial. That necessity is a legal term of art as far as why the case was dismissed, and the fact that half the residents, or 47% of the residents in McPherson County had not been vaccinated, and you had this Delta variant coming, was a satisfactory showing of necessity. And I forgot to mention that on August 25th of 2021, so that would have been the first day of jury trial, the governor herself, Laura Kelly, released new guidance directing state agencies to resume remote work operations due to this Delta variant infection. The state's argument is that the 2 cases do not tack on because of the necessity. And, you know, in addition, we have the prosecutor stated health issues, and he set out all of that, and the court said at the end of that, and this is at volume 5, pages 12 to 13, the court understands that, the problems with his health, the hospital's not taking anybody, and so there's no evidence of bad faith as to why this case was dismissed. It's not supported by substantial competent evidence, and the court erred in finding that there was no necessity on that. Our alternative argument is if the time does tack on, then under the Barker versus Wingo factors, length of delay, reason for the delay, assertion, and prejudice, that there was not a denial of constitutional right to speedy trial under Barker versus Wingo. And recall that the time from the defendant's arrest on January 27th until the case was dismissed on August 24th amounts to about 19 months. However, jury trials were ordered suspended from March of 2020 until April of 2021. So that's 13 of the 19 months that where jury trials were ordered suspended. The time in the refiled case, even saying that it's October 25th when it was filed, and the defendant became aware of it before the summons in February, but from October of 2021 until April 15th of 2022, when the defendant advised he was going to file a speedy trial motion, that amounts to a little more than another 5.5 months. So the time for both cases, not counting COVID, is, you know, just over 12 months. That is factor 1, the length of the delay. Factor 2, the reason for the delay is Supreme Court Administrative Order 2020 PR 16, suspending all jury trials on or after March 18th of 2020. And they resumed in April of 2021. On page 26 of the state's brief, I cited 3 cases from other states that basically say, as the emergency prompting the COVID orders was an external factor outside the court's control, we conclude the second Barker factor does not weigh against the state, or that the delay, and that's State versus Page. State versus Canaster says delay caused by onset of pandemic cannot be attributed as fault to the state. The 2 greatest concerns set out in State versus, in Barker v. Wingo, is a deliberate attempt to delay the trial in order to hamper the defense, or negligence or overcrowded courts are the 2 concerns set out by the Barker court, and none of the reasons involve the state causing or manipulating the delay in bad faith here, so this factor shouldn't weigh against the state. The 3rd factor, the defendant's assertion of his right, he did file a motion to dismiss for speedy trial in August of 2021 or he raised speedy trial when the state sought its first continuance in August of 2021. And there were some hearings during the pandemic where he had requested a jury trial. While this factor may weigh in favor of the defendant, any weight is minimal, and it is not as much as a 3rd factor, which is prejudice to the defendant. And 2 of the judges on this panel were on a case called State versus Rodriguez, where they considered the Barker factors. And we know, as far as prejudice, that the concerns are to prevent oppressive pretrial incarceration. On that point, the defendant was charged with a summons on the refiled case. Contrary to his attorney's argument at the motion to dismiss hearing, he had not been subject to bond supervision on that refiled case. He was on bond on the first case, was not incarcerated, so he doesn't have oppressive pretrial incarceration. Factor 2, minimize anxiety and concern of the accused. This is difficult to factor in because he had another case pending. And if you look at the beginning of the motion to dismiss hearing, he's being sentenced on that other case, which is 21 CR 85. I think he was charged with stalking and pled to violation of a protection order. I'm sorry, that's in volume 2 at pages 2 to 7. So how do you allocate that anxiety when he's got 2 cases pending? The defendant's motion to dismiss does not mention any anxiety on his part, and just saying that he has anxiety about this is not sufficient. I cited a Henderson versus Commonwealth Kentucky case saying anxiety and concern require proof beyond that which accompanies an ordinary prosecution. We don't have the great anxiety in this case. 3rd, to limit the possibility that the defense will be impaired. There is no evidence that any witnesses are unavailable. There was no evidence that the defendant subpoenaed any witnesses. The state had subpoenaed the 2 victims, alleged victims that were in the car, the 3 police officers. They'd all been subpoenaed back in August of 2021. And the state filed this motion for, it's filed its proposed jury instruction. So this doesn't look like this is a case where the state's going to, trying to get out of trying the case, blaming it on.
Yeah, counsel, you've used 11 minutes, so you're
okay.
You're going into rebuttal time.
Thank you. I will just stop at that point. Thank you.
Mr. Dunn, turn it over
may
to
it
you.
please, sorry. My Zoom etiquette's down a little bit from lack of use. May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Mr. Contreras-Avila. As this court might imagine, I see this case entirely, perhaps completely differently than the state. First of all, what this case is really about is the state ignoring every single deadline in front of it. They ignored the constitutional deadlines, underlying his constitutional right to a speedy trial. Then they ignored the deadlines imposed by the rules of the Kansas Supreme Court. And despite those, they were ultimately allowed to reinstate the appeal. And it really, I think it's time that they be held to account. Even though I firmly believe the constitutional speedy trial issue was correctly decided below, I think the first issue is even more important. And I think the timeline in this case is crucial. This case was docketed by the McPherson County Attorney's Office, who remains to this date also one of the counsel of record. Then 2 days later, that happened on August 29th. 2 days later, the Solicitor General's office enters an appearance. A brief due date happens after the transcripts are filed of November 7th. The state files no brief. A suspense order, a courtesy of the court, in which we find no problem with this. Matter of fact, our office greatly appreciates this, was issued setting a new brief due date of December 22nd. At this time saying no extensions, and if you don't do anything, the case is going to be dismissed. The state does nothing. Then on January 4th of 2023, now we're into the next year, nothing has happened, and this court issues an order dismissing the appeal.
I'm sorry, counsel, but let me kind of cut you off because we know what happened. And my question is, despite all that, our court reinstated the appeal. And if your client was dissatisfied with that ruling, wouldn't the remedy have been to file a petition for review?
That is one possible remedy, and I certainly thought about that. But you have cases like State v. Perez, an unpublished opinion in 114-826 case number, and many cases like that, where this court retains an appeal and allows briefing on the jurisdictional issue. And that's how I took this to be, because this is a jurisdictional issue. I think the important thing, and I want this on the record too, the state didn't file a motion to reinstate or technically a motion for rehearing, which would have properly been the motion to do something within 14 days as required under the rules after the order of dismissal. Instead, it was over 4 months later that they moved to reinstate. This means 2 different offices didn't do anything. As to the jurisdictional issue, the mandate should have issued in this case 7 days after the final judgment under the rules. For some reason that didn't happen, but either way, that shouldn't make a difference. There is no jurisdiction once that happens. Another interesting factor is there is no mechanism to reinstate an appeal that late. You have to get into court, you have to have some sort of mechanism.
What authority do you have that we lost jurisdiction to reinstate the appeal?
When the mandate should have, there's nothing directly on it, but when the mandate issues, as it should,
but it did.
A mandate is
issue.
The mandate is a ministerial act. So the fact that for whatever reason it didn't should not benefit the state. I would further add that the fact that if we look to the state's motion to reinstate the appeal, the state explicitly stated, we will ask for no extensions. Presumably that went into the court's consideration when considering its motion. Yet the state requested 3 extensions in this case. So therefore the issue is back in front of the court because they did not do exactly what they said. And again, the ruling was presumably based on all those assertions made by the state.
Given your very limited time, why don't you turn to what happened in district court?
I just feel that I'll move to that in 1 second. I just want to remind the court there is a dearth of cases on good cause and excusable neglect. And for this court to leave it as is, any attorney will be able to cite it when one person makes an error or one firm makes an error. This case says 2 different firms can ignore 3 separate court orders. So moving to the speedy trial.
Judge Hurst, did you have a question? Oh, I'm sorry. Go ahead, Mr. Dunn.
Moving to the speedy trial issue, the state, as the Seinfeld episode goes, kind of yada some things there. A big thing was that Mr. Contreras-Avila began invoking his right to a jury trial in July of 2020. The fact that the word speedy trial weren't used is irrelevant. He was invoking, saying, I want a jury trial. And he did that at every single Zoom hearing that followed. In September, he did that. In November, he did that. This was not something that the state was unaware of or that Mr. Contreras-Avila was just trying to wait to sandbag him at the last second. I'd also point out the Supreme Court, while they did suspend all jury trials on March 18th of 2020, on October or on September 4th, this is what really matters. The public order was issued allowing jury trials to resume. So while individual jurisdictions could still suspend them, that was not statewide at that point in time.
Mr. Dunn, I'm sorry if it's okay with the panel. Even if we assume that rights were violated, it's way too late, way too long. Aren't you required to show a certain amount of prejudice to your client?
Well, again, I want to return to all the other factors, because this is one of the rare cases where every single factor is in Mr. Contreras-Avila's favor. But the fourth factor is prejudice. There's, as the state pointed out, there's three prejudice: oppressive pretrial incarceration, anxiety, and actual hindering of the defense. Now, we don't have an oppressive, I will concede, it's not an oppressive pretrial incarceration situation. However, there certainly was an assertion of anxiety. Not only that, but the state kept ratcheting up the bond conditions in this case. Mr. Benefiel at the March 13th hearing requested and was granted more onerous bond conditions regarding who he could contact and where he could go in McPherson. Mr. Contreras-Avila actually asked for a modification of those because it was preventing him from being able to visit his friends and other people. That never was ever resolved. That motion kept getting put off. I would also note
So
that
does that fall into anxiety, or do you think that falls into, is that akin to being incarcerated?
That's taken into account with oppressive pretrial incarceration is how
Okay.
courts have typically taken that.
So I know you mentioned anxiety, but it has to be, specific and cognizable. And I don't see that.
I'm not sure that it actually has to be specific. The courts recognize that anytime you are charged with something, it causes you particularly a felony, it causes you a fair amount of anxiety. And although some courts have minimized it, the extra-jurisdictional case that Mr. Obermeyer cited might be one of those. However, anxiety is a factor, and it was cited to the district court below and recognized. As to the final, and I would also point out, as to the conditions, he had to request permission to leave the state. Specifically, he wanted to go to his brother's graduation from pharmacy school. He was eventually allowed to go, but that's yet another example on how his life was restricted directly because of the state. Finally, as to prejudice, the state said, oh, there's absolutely no prejudice. That's just not true. The state and everyone was aware that one of the witnesses informed police he was going to be leaving the area. And indeed, by the time of the speedy trial hearing, that witness was, as my old property teacher, Phil De La Torre, used to say, in Tierra del Fuego, nowhere to be found. So that witness is gone. That is actual prejudice to the defense. So that factor most certainly was met. Looping back to
well, I guess before you move on,
sure.
It wasn't clear to me that it was established that he still couldn't have been contacted to be brought back to participate in the trial.
It was the state did not dispute that he was unavailable, and the time to do that was then. The state, as the person with the adverse ruling, had the burden. It's not our burden. Once we say that, and that is affirmative evidence before the court, it is now the state's responsibility to rebut that and say, no, he can be found. But looping back again, and again, prejudice is far from dispositive. If we were looking at a Fifth Amendment analysis of speedy trial, then yeah, it would be. But we're not. This is a Sixth Amendment speedy trial violation challenge. And there are 4 Barker v. Wingo factors. First, length of the delay, 935 days in this case for a simple aggravated assault case.
You're saying if there's no prejudice,
even if there was none,
we can
still 3 other factors.
I know there are 3 other factors, but do you have a case for finding a non-statutory violation where there's no prejudice?
I don't have off the top of my head. This is, again, a balancing factor, and it is a totality of the circumstances. which means, as we all know from, if we want to talk about voluntariness, anytime it's a totality of the circumstances, a dearth of evidence for one factor can be made up for in other factors. But we don't even care about that because I think it's clear we put forth evidence of this, and the district court found these things. Once the district court has found these things, it is the burden of the appellant to show that it was wrong. They can't just baldly assert these things without any proof. I say this because it's usually me in that position. So I am the one that gets to say it's their burden because it is their burden on appeal. So if there's any other questions about prejudice, I was going to move back to the first factor, the length of the delay, which the state conflated with the second factor. It's important to remember these are two different factors, the reasons for the delay and the length of the delay. The length of the delay is solely the time from arrest to dismissal. And in this case, it was joined together because the district court made a factual finding, which, again, I don't get to say this very often. It made a factual finding, which this court has to give deference to, that the state did not do this out of necessity, and it wasn't just about his health concerns.
Are you sure that wouldn't be a legal conclusion?
No, it is
that we can
absolutely not,
review?
because he gets to decide who he believes. And he said, I don't believe you. That's what juries do. They decide who to believe, who not to believe. That is a fact finding. Who to believe, who not to believe.
When did the judge ever said he didn't believe the prosecutor?
The judge said, I do not believe this is out of necessity. You could, if you really meant that, you had all this opportunity to do this before. We had the trial set in March. We have had many cases coming along this way. And many times you knew what everyone knew what the protocols were going to be. This wasn't sprung on the state, like as Mr. Obermeyer tries to say. This was a countywide thing made in conjunction with Judge Dickinson and the McPherson County Health Department, in conjunction looking at what was put out by the Kansas Supreme Court. This wasn't something that happened on August 20th, the day the state decided it wanted its continuance. Keep in mind, on August 19th, the day before, the state told everyone we are ready to go to trial. And yet the next day changed his mind. The district court, taking all these factors, and said, I don't believe it. I don't believe your story here. And then it gave the reasons why it didn't believe him. But as to the legal conclusion, the legal necessity that the state is trying to argue about, oh, he should be able to do this because he has a pre-existing health condition. Prosecutors do not dictate dockets, nor do they make the rules. In particular, in this case, the district court went over all of the protocols, made a meticulous record of how far away everyone was going to be. 15 feet from the podium, the prosecutor was going to be. Jurors all greater than 6 feet apart. Everyone was practicing social distancing. They were releasing jurors based on their word alone that they had COVID symptoms, taking the temperature of everyone as they came in. And they were providing, the district court had obtained 1,000 face masks, which the state agreed were the equivalent, the legal equivalent of a face mask. To allow the state in this case to just say, no, we don't think that's fair, we can do this, gives all the power to the state to run the docket. That's not how things work.
I'm sorry, you have one more minute.
Okay, well, I want to largely focus on this because the district court bent over backwards, even allowed them, the state said, we want plexiglass. The district court said plexiglass will be installed in time. Took extra things, allowed him even to wear a mask. The reason why face masks were used, as we all know, is because to reach the right to a fair trial, you have to be able to see people's faces. So that legal conclusion that the state is now asking, in addition to the factual conclusion, do not add up. The district court was correct. The reasons for the delay, every bit of them was the state. There were only 2 weeks it could be removed. And even if this is where the COVID delay from the court would come in, is the reasons for the delay. Even if you give that, that was only 4.5 months or so, pulling out of 935 days in no way removes it from being a presumptive violation of his speedy trial rights. I've already gone through his assertion of these rights. So I would again, in what little time I have left, if the court has any other questions, otherwise I would say, one, this is a case that never should have gotten to oral argument. It should have been dismissed long ago. And if this court does not dismiss it, it will provide an example for the entire bar of the low standard of good cause and excusable neglect. Even if that's not the case, there is no reason whatsoever that the district court got this wrong. It should be affirmed. Thank you.
All right, thank you, counsel. Mr. Obermeyer, it's your turn for rebuttal. Why don't you with addressing this one witness issue, because I thought it was somewhat speculative that the defense may have trouble getting a witness. Mr. Dunn just said something different, so start off with that.
All right. I think it's in volume 2 at page 39 where defense counsel says he doesn't know where this witness is, that he's not gone. But he does not, I did not read the transcript as defense counsel saying the witness has left the area. And I think that's in volume 2, page 39. We don't know who this witness is. There were, you know, 2 people in a car that were alleged victims and the defendant. It's on videotape. I'm not sure who this victim is. We know nothing about that as far as the witness. I disagree that the district court made factual findings concerning the Barker versus Wingo factors. The only thing the district court did was reaffirm his denial of the motion to continue, basically, and said, I don't find a necessity to dismiss the case. So that just means this court's going to do the heavy lifting as far as Barker versus Wingo, because the district court made none of those findings. The county attorney could wear a face mask except for when he was asking questions of witnesses. And, you know, I guess viruses know whether or not to not float over the plexiglass into, you know, the county attorney's mouth when he's got his mask down. But it was not a bad faith attempt to avoid constitutional speedy trial. The bond conditions, it only came up after the state filed a motion to have bond conditions because the defendant had allegedly violated, had allegedly contacted one of the witnesses. And that's why we got the bond condition. The state didn't object to going to brother's graduation, or there's no objection, no indication of an objection to that. That's not an oppressive incarceration trial condition. There's no, to your question, Judge Hurst, there is no prejudice in this record. And the Gill case even says that statements of counsel concerning that aren't enough. So just saying he has anxiety isn't going to do it. With regard to the attempt to raise an issue on appeal as the appellee, he should have filed a petition for review if he did not like the granting of the motion to reinstate appeal. But I'm just not sure.
You have 1 minute. You have one minute.
Thank you. I'm just not sure the appellate court should get into the business of second guessing what the judge ruling on a motion did. Mr. Dunn filed a response to state's motion to reinstate appeal out of time. Can I now come back and say, hey, you shouldn't have been able to do that? I don't think so. But I don't think you have appellate jurisdiction to reconsider that ruling. I would just ask you to read the county attorney's motion, which is in the appendix to the state's brief. There is no bad faith attempt to avoid constitutional speedy trial. There's no prejudice. And I would ask this court remand the case to district court for trial or for proceedings.
All right, counsel, thank you very much for your briefs and your arguments. The case is now deemed submitted for decision. We'll get an opinion out to you just as soon as we can. That completes today's hearings. Thank you.
Thank you.